You're listening to My HR Buzz, brought to you by My HR Concierge. Hosted by Chris Cooley, we'll bring you various topics and guests to shed light on the often confusing world of HR and also employee screening. We'll be putting the human in human resources.
I think we have a great topic today as we talk about harassment, and we've got two people that you're probably familiar with that have done several of these with us before, and we always have a great reviews of those. And Bill Gault and Wendy Shelton with Nippus, Healy, and Gault. We really appreciate you guys joining us today.
Thank you, Chris. Appreciate being here.
Yeah,
thanks. A great opportunity.
Yeah, thank you. And today we're going to talk about harassment, which is something it seems like is always in the forefront for employers. You know, a lot of times you feel like you're walking on eggshells, and so hopefully we can, you know, kind of walk through this for employers and kind of help them a little bit. And so, you know, I don't want to show my age, but you know, back in the day, back in the you know, when I started managing people back early 2000s, late 1990s, it was very different than it is today as far as what was the norm, what was allowed, those things within the workplace. And so, you know, as we look at it today, you know, what constitutes harassment? How is that defined in today's world?
Oh, the EEOC defines harassment as unwelcome conduct based on race, color, religion, sex, national origin, older age, disability, or genetic information. Within each of those legally protected categories, there are additional areas that could be considered harassment if conduct was based on those, such as gender identity and sexual orientation and pregnancy.
Right. So with that, so we have those different classifications. What makes it harassment? So, for instance, is it you know, where is it where it kind of oversteps that line to where all of a sudden we have a harassment case?
It's over the line if it is both subjectively harassing conduct and objectively harassing conduct. Bill, you can jump in here with me, but the harassment has to be based, as I said, on one of these legally protected characteristics. And it also has to constitute or result in discrimination with respect to a term, condition, or privilege of employment for it to be considered unlawful harassment by the EEOC.
And Wendy, to that point, the standard prior to this EEOC guidance that was issued on April the 29th of this year, you often saw the term, the phrase that the harassing conduct was required to be severe and pervasive within the workplace. And so now you're seeing, or at least the optics are that you're seeing a gradually shrinking of that. One example of it, and they give several examples in the April 29th, 2024 guidance that they issued. For example, one thing I'm seeing a lot of is the concept of misgendering, where an employee wants to identify as a male or female, and then other employees reject that employee's desire to be identified as in the sexual category that individual wishes to be identified. Also, further shrinking of what I'm seeing, you used to have the concept of stray remarks. Just a one-off incident where someone utters something that could be deemed offensive. You're seeing more and more courts saying that a single stray remark can constitute harassment.
Depending on what it pertains to, yes, that is true. The guidance still indicates that one remark might not be sufficient. It might not be severe and pervasive, but some comments are so inflammatory or threatening that they could constitute harassment in and of themselves. The example I believe that was given was mentioning hanging or a noose, something of that nature. One comment like that is considered workplace harassment, whereas one comment about a person's hairstyle or clothing on one particular day might not be.
Yeah, because I know one thing that I'd always heard, or what we've always looked at is you have that, but it's not necessarily the intent, but it's how it makes that person feel or their thoughts, if that makes sense. So it may not to the person that's saying it, it may be a social norm, but it may be something in the workplace that you just can't say, and it makes that particular person feel harassed or upset in some way. I mean, is that kind of how this plays? It's really, I mean, harassment, is it somewhat defined on an individual level? I know there's some court metrics that it has to meet, but is it somehow on that individual level that harassment is measured?
Somewhat. There is a subjective component according to this guidance. There is still also an objective component. So it can't just be that my feelings are hurt and said something about my hair, but if someone makes repeated comments about my hair and my hair is linked to a protected category like race, then that can meet both sides of the equation and be enough. And I am seeing, to your point, more things that you just shouldn't say in the workplace, more and more terms that you shouldn't use, and it's changing a lot, or it has evolved a lot, I would say, in the last 10, 20 years. Bill, would you agree?
Absolutely. You're seeing it a lot easier for a plaintiff to articulate a cause of action based on, to your point, Chris, what they perceive to be harassment. Also, over the years, I've seen the erosion of, or really it's the erosion and expansion. It's generally when you heard the term harassment, you almost immediately associated it with sexual harassment.
Right.
Those terms went hand in hand. Now, as Wendy covered those categories of harassment at the beginning of the podcast, you've got 8 different categories now in which harassment, or they've always been there, but the EEOC in its recent guidance is really dialing in on the fact that harassment is not only limited to sexual harassment, but it's you can have harassment based on race, color, national origin, religion, disability, genetic, age, all of the protected classes.
Yeah.
And even association with a person with a disability. That's in one of the examples. And that one was a little bit surprising to read about. They give an example of someone taking off time to care for a spouse with a disability, and coworkers making negative comments about that person should just go home if they can't be at work, and things of that nature can even be harassment.
Okay. Wow. It's almost if you hurt somebody's feelings.
It's getting close to that.
Thank goodness, though, at least here in Mississippi, we're covered or governed by one of the most conservative Court of Appeals in the nation, in the Fifth Circuit, and also our district court judges. The courts, and Wendy clerked with the U.S. District Courts, so she can speak to this. The courts do not like their dockets bogged down with employment-related claims, and especially in Mississippi and the Fifth Circuit. I think you see a large number of these cases disposed of on summary judgment, but that's still not prohibiting the EEOC from coming in and issuing this new guidance and stepping up their enforcement activity.
And I have seen, I think, a little bit of an uptick in the number of suits that the EEOC is filing based on harassment. They filed 3 in September and 3 in October that I saw, based on sex harassment, retaliation, which is even more prevalent than a harassment claim, is the retaliation claim. So I think that there's definitely a lot of focus at the EEOC on the new guidance and enforcing the new guidance.
And to your point, Wendy, particularly in the pregnancy discrimination and the recent pregnancy act that was implemented last year, I think in maybe January, February of 23, that offers protections to individuals with pregnancy and pregnancy-related conditions.
Good. So, okay, so let's we'll walk that down the path. So we've had an issue. There's been a harassment claim. What do employers need to do to protect themselves once there's a claim? And I guess it's really twofold, right? Because, I mean, there obviously are very, very valid harassment claims. There are ones that are not. And so maybe we kind of walk that path for what an employer needs to do when these harassment cases, present themselves.
I think the first thing that any employer should do is investigate. The worst thing I think that you can do is ignore it. The first thing is to find out whether the alleged harasser is a supervisor, because there's a different standard depending on the answer to that question, whether any employment action at all, even a transfer, was taken against an employee, so that you can analyze very carefully and then make sure that you take corrective action where you need to, because not doing that and just letting things keep going is the worst thing I think that an employer can do. Having good policies is very important. The guidance even sets out some standard things that should be in a good harassment policy.
I totally agree with that. The first step is the policy. You've got to have a policy. It needs to outline the complaint procedure that the employee has to at his or her disposal to go through. It needs to ensure, and this is where a lot of employers get into trouble. They lose sight of the fact of, hey, I'm investigating a claim of sexual harassment or race harassment, and overlook the possibility of retaliation. I have seen many weak harassment claims turned into great retaliation claims.
Yeah.
Because the employer, for whatever reason, unwittingly deems the underlying harassment claim as lacking merit, but then they do something that can constitute retaliation against the employee that filed the harassment claim.
Or they don't even realize there was a harassment claim. It doesn't get properly reported.
Mm-hmm.
So when a personnel action comes through, they're not even aware that this person had made a prior complaint of some sort about harassment. And Bill's right, the retaliation claims a lot of times end up being stronger than the original claim because the employer doesn't very carefully look into any kind of employment action that they're taking to be sure there was nothing behind that. It's also very important that in the policy, there be more than one way for an employee to report harassment. Because if there's only one way to go up the chain of command, and there is a person in the chain of command who is either the harasser or the harasser's best friend, something that would prevent an employee from reporting and it being handled properly, that is a big issue. So the employers all need to have multiple ways to report harassment.
I know one thing we do when we work with our clients is, and a lot of times overlooked when we talk about the service with the client, is an anonymous tip line. I know we have avoided a lot of EEO suits because of that. Or our clients have. I say a lot. We've avoided those suits because what we've had is, to your point, you have that, and whether it's our tip line or somebody else's, you have that other way, because what we find is so many times it's the supervisor that's caused the problem. They have power in that world and those things, and they abuse it. And so that tip line gives them a way to get around that supervisor, if you will, and report that in a way where hopefully they don't have that retaliation. So that's one thing that we see a lot, that we've seen, that we've had good success with, is to be able to ferret out some of that activity through using that tip line. And again, to your point, it just gives another way that they can report those.
Wendy, one thing that I've also seen in some of the and you touched on this in the Supreme Court case in, I think it was Muldrow, that said that used to you had to have adverse employment action was pretty much defined as a loss of pay or benefits. Well, in that case, there was a transfer where there was no economic damage suffered to the employee, but it was deemed to be an adverse employment action. So you've seen a broadening of that. One other area that you're seeing a broadening of is a coworker that witnesses the harassing or alleged harassing conduct, and that employee files a harassment claim. They weren't harassed, but they claimed they were affected by the harassing conduct that was going on, and the employer did not do anything to remedy the issue.
Yes.
Okay.
And another thing that employers should do is have training, regular training on harassment, and make sure that all employees know what it is, know to report it, make sure that that training is up to date and done regularly.
Yeah, no, I agree. And does that, how does that, so if that employer has that training, they're doing that, a lot of states now require it annually or whatever that may be. Does that, by doing that, having them sign that they've had it, having records of that training, does that insulate the company in any way if that employee or maybe that person taking that training is a supervisor? If they perform harassment, does that help insulate that company in that we have policies, we have trainings, we have these things, but yet they still perform that? They still have that harassment or whatever that may be. Does that help insulate the company?
It does help, depending on whether there was quid pro quo harassment. In that case, it may not help, but in other types of harassment, employee on employee and supervisor harassment that doesn't result in an effect on an employment benefit, it can help show that the employer is not permitting the harassment, is doing everything it can to prevent the harassment and provide a defense, as long as there is a policy to report and the employee reports the harassment and the employer takes corrective action.
I agree. The one of the defenses available is that if the employer had a anti-harassment policy, anti-discrimination policy, and the employee failed to avail themselves to the use of that policy, then that can constitute a legal defense.
So in stepping back just a little bit, one thing I did want to talk a little bit about is retaliation, because that obviously a lot of these companies are at risk. What constitutes retaliation? If so what does an employer do? What's kind of that definition, and then maybe some examples of that?
Retaliation is a little bit different standard, and as we were saying earlier, it can be easier for an employee to establish a retaliation claim than the actual harassment claim. And there are claims that are both a harassment claim and a retaliation claim. But the standard is a little bit different. To support a retaliation claim, the conduct can be conduct that would chill or prevent a reasonable employee from reporting harassment. So if someone received negative reviews, negative comments after they reported harassment, that could be seen as retaliation, because that is something that could be viewed as preventing a reasonable employee from reporting harassment.
Okay.
And I think, Wendy, let me see if you agree with this. Say an employee files a charge of discrimination or harassment with the EEOC. The EEOC finds that there's no basis to believe that discrimination occurred. And then the employer comes in and takes an adverse employment action against that individual, even though the underlying claim had no validity. Then I think they have a legitimate basis to file a retaliation claim.
Absolutely. I agree with that. And that's what I would say we see more frequently. And the retaliation numbers, those claims are filed even more often than harassment claims.
Yeah, I know one thing that we run across periodically is where something like this occurs. The first thing that maybe that owner or manager does is they say, well, you need to go to another store. You need to go to another location. We can't have y'all work together. We're going to change your shift. You're going to go to the night shift, those kind of things. And they need to be very careful with that as well. Because if they're either having to drive further to work or work maybe a night shift, it could affect their home life with their kids, those kind of things. That can be retaliatory as well, correct?
Absolutely.
And so if we think through, so we've got the harassment claim, we've talked about the retaliation, those things, and some things that company can do to prevent. One thing that when it gets to a claim, we help kind of gather the information, and then we hand it off to our client, and they have an attorney involved, right? But a lot of times we'll kind of walk through the process with them a little bit, just so they kind of understand what's to come up. And there's, as I understand it, you guys know better than I, there's really two things that can happen through that process. They can go to a mediation, or they could eventually go to court, or maybe both. Maybe they don't make it through the mediation. What is kind of in your perspective, when is the right time to go to a mediation? When is that? Because I think a lot of employers don't realize that that's available. So as they're walking through that EEO, what should they consider when they're thinking about that mediation?
Wendy, since I had a mediation last Thursday, and the EEOC doesn't always issue invitations to mediate.
Okay.
First, if they think that there's a strong likelihood that there's a violation, they may not even ask you to mediate. But assuming you get a offer to mediate, I always accept that offer, and the reason being is that it's non-binding. It's supposedly totally confidential and separate from the enforcement side of the EEOC that would do the formal investigation and enforcement if the case wasn't resolved in mediation. And you get free discovery. You find out what the other side's got, and there are always surprises. The employer never tells or I shouldn't say never, but very often never tells the attorney everything that has gone on. So you get to evaluate the charging party. You get to look at them. Usually, sometimes the charging party will have an attorney, and you may only get to hear from the attorney, but you're still getting valuable insight to what this case is about, and what claims and defenses that you may have, and what allegations you have to be able to overcome. And so I always choose mediation, even if I don't think it's going to resolve in mediation. For that purpose. And then if it doesn't resolve in mediation, then they refer it to formal investigation. You submit your position statement. And I will say this, the EEOC, through its portal process, has made the mediation, they do a lot of them by Zoom now. I did one by Zoom, and my EEOC mediator was in New Jersey. Used to, you would go down to the federal building here in Jackson, and you would have in-person mediations. You can still get an in-person mediation, but it's going to take weeks or months to get one scheduled. Whereas if you do it by Zoom, you can get it quickly. It's pretty effective in my opinion. We resolved the one I did last Thursday, and it was a good process.
I would completely agree. The last couple I've done have been by Zoom, and I have had a client say, no, I'm not doing it because I'm not paying anything. But through mediation, we were able to resolve with a neutral employment reference. So I really encourage that process. We had a really sharp mediator who understood the issues very clearly and was able to get to a resolution quickly. I have had the opposite too, where it just sort of took hours and hours and we didn't get anywhere. But overall, I find them to be very beneficial.
Yeah.
I know years ago when I was with another company, we had a sexual harassment claim, and it was one where we pretty much knew it was a false claim. We hired we actually were so, we felt it was such a bad claim. It was a gentleman that filed a claim against his supervisor, who was a woman. And what we found was, we actually put a private investigator involved and all that kind of good stuff. But anyway, what we found was he didn't get the the promotion that she got. So he had told a coworker, we'll see how they like it when she gets a harassment claim. So anyway, it was pretty cut and dry. So I know we went to mediation, and at the end of the process, the mediator went to the other party and just said, you don't have a case. Y'all just need to walk away.
Mhm.
And so it was great for us. We didn't have the court fees. And then that mediator pretty much enforced our stance that it's just not a valid claim. And so we were able to get out of the expense involved in the court, going through a court case and all those things. So I agree. I think it's a great way to hopefully come to a conclusion that's best for all parties.
Well, it certainly saves the time and the expense of litigation, going through depositions and discovery, disruption of the employer's workplace in having to deal with those kind of claims and lawsuits.
Mm-hmm. Absolutely.
If I could go back for a minute, I
Yeah.
found what I was looking for on retaliation. The EEOC prohibits retaliation when employees engage in protected activity, opposing unlawful discrimination or participating in an investigation, hearing, or proceeding. That, because of their protected activity part, can get really fact intensive, and there's a bigger risk, I think, of getting past summary judgment on a retaliation claim just because of that. What do you think about that, Bill?
Absolutely. And even, which goes back to the point I was making earlier, even where a coworker that's not the subject of the harassing activity, if they report that conduct and then they get retaliated against, then it's a potential for a basis for a retaliation claim.
I don't know, one thing you said earlier, Wendy, that we saw play out where it was a chain of restaurants, and the supervisor, there was a harassment claim against the supervisor, but the supervisor didn't know it because it was linked. They sent it to corporate, and so in the meantime, that supervisor was trying to terminate that employee while they had an active harassment claim going on. And so, yeah, so it's really important that these employers communicate. And I know they were doing that for confidentiality reasons. But one thing employers, specifically these multi-location, there does need to be some chain of command or some process from which, when they do these terminations, that they're cleared by a corporate entity or somebody to make sure that there aren't other things involved in the termination.
And I have seen that more than once happen, where there might be something legitimate to discipline or terminate an employee for, but the person actually to whom that decision came to sign off on didn't know about an underlying claim of harassment.
One thing too, I did want to bring up, we run into this a lot as well, and I can kind of get your thoughts. We hear a lot of times, we work with small companies, big companies, and in between. From a lot of the smaller companies, what we get is, we don't have to worry about it. We're a family. We're a family here. We don't have cases. We don't have harassment. We don't have any of those things. And so one thing, and I get that. If you're in a small business, 5 people, 10 people, 15 people, 20, there is a more of a family feel. And when that occurs, a lot of times those curtains drop between what is and is not acceptable in the workplace. And so we find that issues rise there, because generally it's a great environment and everybody loves everybody until somebody's terminated.
And those look the worst on paper, because you can't, when you're reading a decision, you're reading a complaint, you can't tell how close they all were. And maybe at one point comments like what you're reading that sound horrible on paper were welcome, but at a point they have become unwelcome. Everyone gets too familiar, crosses the line, someone gets angry. I would say those are some of the worst cases to read about, where everyone thought they were all on the same page, but when jokes and things like that get put in writing, come out in a case, it looks terrible. People were not careful enough, as you said. Their guard was down because they thought this wasn't going any further than their little family, and then it ends up national news.
Yeah.
Well, Chris, one thing I always try to dispose of these smaller employers cases with. First question: how many employees do you have? Because if they've got 15 or less, they're for the most part they're not going to be subject to the EEOC jurisdiction. So, and it's amazing how many times over the years that issue has turned on how many employees you have. Because the EEOC's got a pretty I don't know if it's complicated, but they've got a pretty broad way that they look at it. I believe, Wendy, they look at the 52-week period before and the 52-week period after the alleged discrimination to determine the number of employees that were in the workplace at the time of the alleged discriminatory act.
They do, and don't they use some formula too, or some measure is for 20 weeks or more? I mean, there is
absolutely, yeah. Did they work during that 52-week period of time? Did they work 20 or more weeks? Yeah.
So, and then you get into arguments about whether they were or weren't employees. Like it goes downhill fast. Sometimes employers legitimately are too small to be covered, but that defense doesn't prevail that terribly often, I would say.
Well, good. Well, what we kind of walked through most of that process. What have I missed? Is there anything else that you think we need to cover while we're talking?
The one thing that's often missed is, from my practice standpoint, is EPLI coverage.
That's a good point. Yeah.
Invariably, I've had employers get involved. I have one case one time where my client had an EPLI policy, and I asked them on the front end. I said, "Do you have employment practice liability insurance?" "Oh, no." Well, we go through the EEOC process and go through formal investigation. Mediation didn't work, so we went through formal investigation. EEOC issues a notice of right and what we call a right to sue letter, finding that there was no reason to believe that discrimination occurred. Then the lawsuit was filed within 90 days in federal court. And then the employer discovers, oh, well, we do have a EPLI policy. And so we put the insurance carrier on notice, even though we had gotten the best outcome we could have gotten in terms of a right to sue letter with no cause to believe discrimination occurred, and the carrier denied coverage because you didn't timely notify them of the claim. So always check and double check. Make sure, because a lot of the maybe supervisory level individuals that you're dealing with, they don't know what insurance coverage the company has.
Yeah.
And with the smaller ones, maybe they just want to see how it goes first, but you really can't do that, as evidenced by what Bill was just talking about. You can't wait and decide once you see if they're really going to sue you in federal court.
Yeah. For those that may not be aware, what is EPLI? What does that help that employer with? What does that cover?
The policies I've read, they're pretty broad. It they apply to any discriminatory employment-related action that occurs in the workplace. I've had them apply to, which is a little unusual, a unfair labor practice charge. The insurance carriers are pretty. I mean, when they put this product together, this product's only been around, I think, Wendy, since the mid '80s, and it became to be the big in vogue thing.
Mm-hmm.
One thing about EPLI coverage, though, I have found that their retention or deductibles are very high, usually $20,000-$25,000. And the truth of the matter is, a lot of your EEOC charges are resolved for a lot less than that amount of money.
So it's catastrophic insurance almost in that case. It's if something really happens and there is a big settlement, I guess. Mm-hmm. I know one thing we do when we bring on a new client, we take them through a checklist, right? So we're trying to figure out essentially maybe where they have areas of risk, where we then can help them with those areas of risk. And one of those questions we always ask is, do you have EPLI insurance? Because that is something we recommend, just in case. And it's generally fairly cheap typically. So we always thought it made sense to have that. So, well, great. Well, look, I really appreciate you two being on with us. And if somebody needed to reach out, if they need help, how do they reach out?
Yeah. I'll give my email and contact information. My office phone is 601-952-2592, extension 110. My email address is bgault, that's BGAULT, at billgaultlaw.com, bgault@billgaultlaw.com. And if anyone has any questions about any of the matters we've discussed, don't hesitate to reach out to us.
And I'll get my number. It's 601-955-7352.
Perfect. Thank you very much. You guys are always some of my favorite guests, so I appreciate you jumping on, and I really appreciate it.
Well, we appreciate you having us.
Thank you.
Thank you.
Thank you.
Thank you for listening to the My HR Buzz podcast, presented by My HR Concierge. For more information on this topic and many others, please visit our blog at www.myhrbuzz.com. It's a free resource and has a lot of great information on HR and employee screening related topics. If you like the podcast, please do 3 things for us. 1, leave a review. 2, subscribe to the podcast. And 3, tell a friend. Our podcasts are available on iTunes, Spotify, and many other places where you get your favorite podcasts. If you'd like to provide ideas or feedback on future shows, send us an email at podcast@myhrbuzz.com, or you can reach us at 855-538-6947, extension 108. This is Chris Cooley with My HR Concierge. Thank you for joining us, and we look forward to sharing more topics with you in the future.